Now we've just done your unsecured priority claims, and we've finishing that up. Here's where we're going to list all those claims, and we'll give the name and address of the creditors. No, there's a number of rules on this, and I'll handle it. I just need to know who they are so I can list those properly. Now here's your big one, Schedule F. This will have the most number of pages in most consumer bankruptcies of any other schedule. This is where we list all of your unsecured claims, your credit card debts, your hospital bills, anybody else you might owe. Now, I've undoubtedly pointed it out in a number of places in the tutorial, but let me say it again. The only creditors that are discharged are the creditors that we list in your bankruptcy and those that we send a notice to. So those are the two requirements. So it's real important that we get all your creditors. We don't want to end up with one or two creditors who said, well, you didn't list me in the bankruptcy and or you didn't send me a notice, so you still owe me. No, we need to list everybody. And again, I've pointed out, let's say you're going to repay somebody. So you think, well, I just won't list them. Well, no, when you go to the 341 meeting, you're going to be required to fill out a questionnaire under oath, and that will always be one of the specific questions that you're asked is, did you list all your creditors? Well, you don't want to lie. That's perjury. So you're going to list all your creditors. Now, in Chapter 7, if you want to repay any creditor after we file, you can certainly do that, but they need to be listed in Schedule F, even if you intend to repay them. Now, on Schedule F for Chapter 13, you can't do that because you're paying your unsecured creditors through a Chapter 13 plan, and you can't show favoritism to any one of them. So watch the video on the exemptions, and be sure to go through the series on competing interests. It's like there's a number of chess games going on at the same time in a consumer bankruptcy. But the important thing I want you to get out of this right now is we need to list every creditor that you've got. So again, we're going to list the last 4 digits of whatever the account number is with that creditor. If you have a co-debtor, who incurred the debt, you or your wife or both of you, the date the claim was incurred and the consideration. There are rules for completing this form, and in the video that I provide to my clients, I'll give you all those rules so that you can help me get all this accurately. Unexpired leases and executory contracts. Executory is a word that we don't use in everyday English, so you think, well, gosh, what's that? Well, let me give you, it's easier for me to explain it by examples. Let's say that you have a apartment that you're renting. Well, you've got a rental agreement with your landlord. Well, that's an executory contract. It means that performance is largely incomplete on both sides. If you've got a rent-to-own agreement on furniture or appliances or something like that, that is a executory contract that we're going to list. If you have a lease on your automobile, again, it may be listed on this schedule, but if you'll bring that lease agreement into me, depending on the provisions within that lease agreement, it may be, even though they've got a different name at the top of the agreement, it may legally be a secured loan. And if that's the case, then the rules are completely different. So if you have a lease agreement on anything, when you meet with me, bring that agreement in so I can take a look at it. Codebtors. I know that most of us, we don't think of a codebtor as our creditor. But if you don't pay the debt that your codebtor guaranteed, let's say your codebtor had to pay the loan, well, he would then become your creditor. So we're going to list every codebtor that you have on any loan, secured, unsecured, whatever. To remind you, in Chapter 13, codebtors are protected for consumer loans. So let me give you an example. Let's say you got a car loan, and the lender wanted additional security, so your parents co-signed. Well, if you are going to repay that auto loan in your Chapter 13, even if it's delinquent, that's fine. We can work that out. But in a Chapter 13, not only can the creditor take no action against you, they also can't take any action against your parents, who are your codebtors. So that's an important and major protection for people in Chapter 13. Schedule I. This one this and the next schedule, they're very different than the other schedules and declarations in your petition. This is you and I doing our best to look into the future as to what your income is going to be. Now, I'm going to pull up a lot of data from your wage statements as to what the historical income is. But even with that, we very frequently have to adjust it to make sure that we've done a good, accurate job of what you and I think your future income is going to be. So if you look down here, we've got your gross income from your wages and then what's taken out of your wages. Well, I can pick up all that data, historical at least, from your paychecks. Regular income and retirement income. It's just all your sources of income coming into your household. So this is not a difficult section to complete, but we want to be accurate. Now, number 17 is important, and it's frequently overlooked because attorneys don't do a good job of following the form. Describe any increase or decrease in income reasonably anticipated. Well, let's say that you've been working quite a bit of overtime, but you're not going to get any overtime anymore, and you know it. Well, that's where we're going to make a notation of that. Maybe you're going to be cut down on the number of hours you're going to work. A lot of companies are doing that. So that's where we would make a notation about that. Now, Schedule J, Schedule I is your income. Schedule J is your expenses. And you and I will go through this and we'll list out what all your monthly household expenses are. Now, there are IRS guidelines on what they think is reasonable, and I'm aware of all those. So I'm going to guide you a little bit as we do Schedule J to make sure that your expenses are in compliance with that. Almost always they're going to be, but I need to protect you on that. We're going to list all of your expenses. Now, let me give you some practical repercussions of this schedule. Let's say that we're doing a Chapter 13 plan, and you and I figure up that in order to make the payments in your Chapter 13, you're going to have to pay into the bankruptcy court $400 a month. Well, when we do Schedules I and J, we're going to have to end up with net income down on 20C. We're going to have to end up with enough to show that we could make that payment. So that's one application of what they're going to use Schedules I and J for. Let me give you another one. Let's say that we're just doing a Chapter 7, and we put down all your income, we put down all your expenses, and we end up with $500 a month unspent. Well, they're not going to let you do a Chapter 7 under those circumstances, because they would say, well, you have $500 a month to pay creditors with. We are going to make you do a Chapter 13. So all of these have to be filled out with knowledge as to what their impact is. And that's part of my job as your attorney, to protect you on that. Now, from a practical standpoint, if we actually go through all your income and expense, you're not going to have any money. The American people are broke today. So I just need to fill this out so that you're protected. But don't worry about it. It's not a problem. We're just going to have to, I need to explain to you what the repercussions are. And again, you're going to sign this declaration that all of the schedules that we've went through so far, that they're true and accurate. You're going to sign that under penalty of perjury. You know, they don't, again, I'm going to beat this to death. They don't, coming close isn't sufficient. You and I have to list everything that we think needs to be listed. So don't be casual about it. If you're not represented by me and you've got some attorney who says, well, we'll fill it in later, we'll amend it. No, don't be that way, because your credibility is then at risk. When were you telling the truth? When you filed the petition, or when you did the amendment? So no, you be accurate and truthful from the get-go, and then you and I are going to be okay. That's not so much your job as it is mine to make sure that we do it properly.